saying, today is the second in a series of presentations that we have arranged on the issue of preventative measures. I'm a solicitor and senior associate at IDR. It's a specialist contentious probate practice, and I've been practicing in contested matters and litigation for nearly 15 years. And over that time, I've seen numerous disputes escalate to the point that settlement isn't possible. Settlement attempts have been made but failed. And there are numerous triggers that can push a dispute into that position. And for me, it's an important factor in providing early and sensible advice to clients on the risks of reaching a contested trial. I'm really pleased to be joined today by William Moffat of Radcliffe Chambers. We wanted to ensure that it was both solicitor and counsel's views that were being provided today, because the story of a piece of litigation involves various legal professionals. It involves a team, and within that team is solicitor representation, the day-to-day, dealing with the minutiae, dealing with the correspondence, and counsel's involvement up to trial. And we thought it would be important to offer that broad scope of insight today. So we wanted to look today at this journey of a piece of litigation, and we hope that it's useful to contentious and non-contentious practitioners, and those who work, in the inheritance and family succession sector as a whole. So today isn't about updating on very technical legal points, but really taking that step back and looking at the journey of a client walking into a solicitor's office, and then triggers that escalate matters leading to a dispute and bring the matter to the courtroom. We are looking at the issues that can arise in the making of a will, and we're looking at the ways that will writers can protect both themselves and the testator and beneficiaries from later claims. So in dealing with that, we also touch on post-death issues. So what happens after the testator has died? The issues that can arise with executors appointed, and those crucial first 6 months after the grant has been obtained.
Thank you.
We look then at the subsequent dispute, what issues can prevent settlement, and when a case is too far gone and trial is ultimately inevitable. We'll hear from William shortly, so I'll press on and talk through what those initial steps are that the will writers, the will draftsmen can use to help mitigate things. Ultimately, it all starts with the testator, and what we're looking at here is these common pitfalls that can arise, and how things can go wrong, but steps that can be taken to mitigate things. The will writer has a crucial role, and when the client walks into a solicitor's office, it is at that point that the will writer's duty and their expertise comes into play, and they have a responsibility to make sure that there are elements of the instructions that are being taken that ensure that the testator knows exactly what they're doing, but also that they are using their expertise to assess whether there are any triggers or red flags which make them consider whether or not there is a risk here. These risks tend to arise later. These points tend to arise later in terms of a challenge to the estate and a challenge to the will that has been drafted. Of course, if a will writer is presented with a client who doesn't have capacity, then they don't have capacity to instruct them, and that is a different situation altogether. But what we're looking at here is the ways in which the will writer can really narrow down and drill down into the detail with the testator to ensure that their wishes are properly being carried out, of course, but that they're aware of the risks that can arise if a claim is brought. So specifically, we're looking at whether there are any risks of a challenge to say that the testator did not have testamentary capacity, whether they knew what they were signing, whether they were familiar and were happy with the extent of the dispositions that they were making in the will, and also that they weren't under any sort of influence from a third party. We are all familiar with the test that the court applies in assessing capacity. And we're also all familiar with the ways in which a will writer might approach that first meeting with a client. That first meeting is not one in which the will writer is required to conduct a capacity assessment. That isn't their role. The role is really to take instructions on the will, to discuss any previous wills that have been made, and also to see if there are any of these red flags. But what the courts do want you to do is to use your common sense, and to, as a matter of best practice, to apply the golden rule, or at the very least, to be looking sensibly at the way in which the testator is receiving and providing information to you. The courts have been quite clear that the application of the golden rule, namely to seek a medical assessment if a testator is elderly or vulnerable, is not mandatory. It is an indicator of best practice. However, there have been a number of cases where the golden rule has been followed and capacity assessment has been carried out. But even in those circumstances, the will has been found to be invalid. So this is about protection for the will writer as much as anything else, taking these steps both to justify the making of the will in the way that it is, and to justify the fact that the instructions have been taken carefully and due consideration has been given to the testator's capacity. In terms of the lack of knowledge and approval, clearly if the testator lacks capacity, or if they do not understand what they are signing, then this can give rise to this element of challenge. Where there is a testator walking into a solicitor's office to provide those instructions and the solicitor is drafting the will for them, there's a presumption that they have sat there and reviewed the will, and that the solicitor has advised them accordingly. However, we've seen again a number of cases where solicitors take instructions from third parties, or the third party is in attendance with the testator, and it is them who are effectively giving those instructions and giving those elements of the dispositions to be put in the will to the solicitor for drafting. So in those circumstances, the courts will consider this to be an issue and not something that can just be justified by a really well-prepared attendance note. The reason for this, of course, is that there is a potential challenge for lack of knowledge and approval, but also undue influence. If a third party is attending an appointment to make a will with a testator, then this should be raising red flags. There should be, at the very least, a meeting alone with the testator for the solicitor to ensure that those instructions are understood and are being freely given by the testator. When we look at will writers' files in contested probate litigation, they tend to be one of the first pieces of evidence that we see. They tend to be the set of documents which is pored over with such a fine-tooth comb that we see, the really excellent solicitors' files, and we see some really sparse, files which just do not show the record of the instructions or the advice, or even the sort of the discussion of the dispositions. So it can really range in quality of evidence, but If from the will writer's perspective, you are trying to protect yourself and your firm from a claim, then it is, of course, good practice to make sure that everything is recorded and everything is made clear on the file, both to assist the litigation later, to assist the resolving of a dispute, but also to justify the work that has been done. From our perspective, these are the key points that we will advise will writers on, and they are, to some extent obvious, but taking a step back when everybody is busy and instructions are flying through the door, it can be difficult to make sure that these points of compliance are met. So who are you taking instructions from? Is it the daughter? Is it the son? Or is it the testator themselves? And if you are being approached to set up an appointment by a son or daughter, make sure that there is time set aside to sit with the testator alone and to talk through everything that is being discussed. Develop a checklist for key questions. There are key points to raise with testators. Talk to them about people, talk to them about property, talk to them about who they look after, who lives in their house, what sort of testamentary giving have they done previously, or lifetime giving. What do they want to achieve with this will? Consider risk factors, vulnerability, any element of incapacity. Consider whether there is a risk factor indeed in the third party attending with them. Keep accurate and detailed attendance notes. This is the real measure of a quality solicitor's file, whether or not there are detailed attendance notes explaining points to the client and recording those explanations. But also, these attendance notes serve as an excellent aid memoir for solicitors who are required to give evidence at trial on the instructions that were given. It is important, once those instructions are given, to reflect on them. Is there anything that needs to be considered again? Is there anything that the testator needs advice on? But don't let this delay things. The instructions are given and the will must be drafted promptly. Otherwise, there may be a claim for that delay. The clear instructions on the execution of the will must be given at the time of execution if that is not done in the office. And also clarify storage arrangements. We've seen numerous cases of copy wills having to be presented for probate because some testators simply do not realise that the original is the original and it's thrown away, or it's left somewhere, which means that it is not kept safe, and that can cause numerous issues. Even if it isn't anything to do with the distribution of the estate, it can cause issues for those administering. The point about taking instructions from the testator is one that can be easily overlooked. It sounds obvious, but of course, where it is an elderly testator, then their children or relatives may very well be making arrangements for them, particularly if, as most firms now operate using email and providing electronic documents or electronic advice by email. The testator may not be familiar with this. They may not want to operate in that way. And so the sons or daughters or relatives step in to be that conduit. We've seen, a number of issues where actually this isn't evidence of undue influence by any means. It's, it's the son or daughter trying to help. But of course, it prevents the solicitor from being able to make those initial assessments, to consider those risk factors, and actually to probe in more detail about the testator's property and affairs, which the son or daughter may not be privy to, including potential claimants on the estate. The checklist that we always suggest that will writers use is one which, again, it sounds obvious, but having this consistency on each file where you can turn back to it. It serves as a prompt for questions in the first interview, but likewise, it serves as a point for reflection upon taking those initial instructions. It's simple stuff. Check names, check who owns the property, uh, do a family tree. Even a simple family tree can help a testator to understand who they may owe obligations to, or who they may be looking after, in one sense or another, which might lead to a claim if that person is left out of the will. Um, Particularly where there are issues of property ownership, if there has been severance of joint tenancy, that should be checked. And primarily, how the client is presenting themselves. Do they appear well? Are there any risk factors here that we need to be aware of? And that's something that can be revisited across the course of instructions, particularly if a testator is changing their mind. The risk factors I've identified here are points which can fall by the wayside when you are not seeing clients face to face. If you are having telephone consultations, or even if you're having video calls with clients, some of these risk factors can be missed, particularly with appearance, particularly with the way in which they are sort of conducting themselves. If you can only see a head and shoulders, you may not be able to sort of truly assess whether the testator is well, or whether there are issues of vulnerability which need to be aware of. There are other factors, of course, which ought to be picked up by the checklist. So, considering previous wills, considering what those wills contained, and what the testator is trying to achieve. If there's issues with forgetfulness there, or really key points which the testator can't remember, then that needs to be addressed. And as insensitive as it can sound, the golden rule at that point comes into its own. This is a point of best practice for us. We want to make sure that we are helping you to avoid a claim, and this is why we recommend a capacity assessment. If handled sensitively, testators do tend to understand the reasons for it, and in the interest of avoiding trouble for their children after they've gone, they will agree to it. But it is a hard sell, and I think that particularly if there are concerns here, it can be difficult to justify the need for a capacity assessment sensitively. The issue of attendance notes, as I've said, is both to ensure that the quality of the will file is good, and that it's detailed, and that it can be clearly seen that the advice and the explanations that were given. But it is also a useful tool for the solicitor if evidence is required. It tends to be the case that if a solicitor is called to give evidence about the instructions that were provided to them, that this is many, many years after after those instructions were given, and many, many clients intervening. So there is a real benefit to having that file to review for the solicitor's purposes, and for the purposes of any professional indemnity insurance that needs to be called upon. Having that quality file, the evidence there, the clear attendance notes and records of the advice given will be invaluable. The delay point we talked about earlier, but this is something which we've seen numerous times before the courts, and we've seen claims be brought for delay. Where the solicitors just simply haven't turned things around in an appropriate time. This may have been for all sorts of really good reasons, but it's important to be aware of it. You can specify the timescale for production of a will, absolutely, and that can be agreed between the solicitor and the testator. And certainly, where that timescale is in place, a solicitor couldn't then be liable for the failure to prepare the will within that timescale if the testator dies. And similarly, if instructions haven't been accepted, then there could be no argument that the solicitor was negligent in not preparing a will. But if you do agree at a timescale, you've got to stick to it. The execution of the will, again, numerous times before the court to resolve issues of execution. The solicitor, the will writer, ought to be very clear about what needs to be done if the execution of the will isn't going to take place in the office. Similarly, where there needs to be a check on the identity of witnesses, one case comes to mind where the witness coincidentally had the same name as the testator, and there was a need in those circumstances for the solicitor to undertake identity checks on the witness. These sorts of points should be obvious at the time, but again can easily be missed if the testator is taking the will away with them to be executed at home or some other place. Where we are looking at situations where will writers are taking instructions by phone and then things are sent through the post to them, make it clear in the covering letter that you are sending the will for execution, make it clear that that will is going to be the original will, and give guidance on storage arrangements for it. Once that has all taken place and once everything has been signed by the client, if there are any issues at that point, does there need to be an endorsement on the reverse of the will? Do you need to step in here and make sure that an attendance note or even an affidavit of execution is prepared so that it explains any sort of issues at that point? This is something that ought to be identified at the time and is most likely to be identified at the time if there is if the will is executed in the solicitor's office. But otherwise it is something to be aware of, and there needs to be that checking in with the client post execution in any event to make sure that everything has been done properly. This is the sort of thing that ought to be in the checklist for the file to make sure that everything's been done and that there has been an element of conclusion here. Where the will has been signed beautifully and it is being held perhaps at the solicitor's office in the strong room, is it to be registered anywhere? Who needs to be notified that this will is here? Ought they to be told that if they plan to marry or to move house or to have children, they ought to reconsider the terms of the will? These points are, generally around client care and client service, but also to prevent there being issues on identification and location of an original will as and when the grant needs to be obtained. Turning to that point, when the testator has passed away and the administration needs to begin, we see numerous triggers for potential disputes right at the beginning. So we've seen situations where executors are appointed and they are perhaps relatives or friends of the deceased. There is a real risk here where those executors step beyond their role of neutrality where there are disputes between the beneficiaries. We've seen situations where those executors are appointed, but that actually that person has a claim on the estate, and there ensues an issue of conflict of interest in that role, which again steps beyond and outside their role of neutrality and that really key neutral voice, which can so often be the calming and sensible voice when it comes to disputes within an estate. We've also seen situations where executors do not preserve the estate assets. Things are sold very quickly, things are distributed too early. There is a crucial 6 months period after the grant has been obtained, 6 months being the limitation for issuing claims under the Inheritance Act. And where that is missed, where the executor isn't properly advised, where they are just trying to go it alone and effectively try to deal with things quickly and wrap it up, the distribution of those assets before any claim has been resolved can lead to personal liability for the executors. If assets are wrongfully distributed, then it'll be the executor's next on the line. And if they're not properly advised during this point, then steps can be taken which can cause them problems later down the line, either because they have conducted themselves to such a terrible way that they need to be removed, which delays everything and is costly to the estate, or they have some element of personal liability there. So this is a real trigger point. These first 6 months are crucial. Sensible advice being provided to the executors is key at this stage. Then once we get to a point where the dispute is well and truly underway, we can often see significant early hostility between parties. We can also see situations where the parties are entirely focused on bringing this to a sensible and early conclusion, which is helpful and means that, you know, when the lawyers get involved, we can look at a quick resolution and we can help them to reach that in a sensible and formal way. But otherwise, we have parties at war, we have contested litigation, we have situations where claims are issued without engagement in pre-action conduct. And, you know, when the dispute is well and truly underway, we have to deal with it, and we have to be mindful of the ways in which we can support the parties to bring matters to a resolution at the earliest possible stage, if that is at all possible. I want to turn to William now, just to provide some input on the point at which counsel becomes involved in that dispute, and when that should be, and how that works practically.
No, thank you. Thank you also for inviting me to join you on this webinar. Yeah, the bad news is counsel were involved when the dispute's arisen. I suppose the good news is that it doesn't necessarily mean, because there is a dispute, that the will writer has done anything wrong. Some disputes, in my experience, are just unavoidable. There's trouble brewing from a long time in the past. However impeccably the will writer does their job, has recorded the process, has recorded the instructions, some disputes are going to arise. I'll give a couple of examples. It may be that it's nothing to do with the will-making process itself. It may be there's a dispute about the ownership of the assets in the estate. So a typical example might be a farmer who's promised his eldest son that he'll inherit the farm, but nothing's committed to writing. But when the old farmer comes to make his will, has decided he's fallen out with his son and is going to disinherit him. Now, the son might have a proprietary estoppel claim, which is beyond the power of the will writer to resolve in that meeting. Similarly, there may be claims on the estate under the Inheritance Provision for Family Independence Act 1975. Your testator may be very clear about why they want to disinherit a particular relative or dependent, such as the testatrix in the famous case of Islet and Mitson, the lady who was very clear about not wanting to benefit her daughter with whom she'd fallen out. And the will maker in that case, the sister, made very clear, notes was absolutely clear that the old lady had reasons for doing so, but the court intervened, albeit to a limited extent in that case. And it's the most you can do in that situation, I think, is to advise of the risk, to perhaps point to ways in which they may be able to resolve these issues in their lifetimes. But ultimately, your duty as a will writer is to give effect to assist in the preparation of a will that reflects true intentions of a capable testator, however much emotion that might stir up between family members who have grievances. I mean, very often cases reach court between warring siblings. So a parent who's decided to disinherit one of their children in favor of the others. And there's so much emotional baggage in that process that you can see sometimes there's almost a compulsion on the disinherited party to try to challenge it with coming from a very strong place of emotion rather than necessarily merit. You may find very often these days second marriage situations in which the first of a couple to die leaves everything to a spouse for a second marriage, and that spouse decides not to favour the children of the deceased first marriage. And there's trouble brewing from that point on. So I'd say not necessarily is there any indication of fault with the fact that these disputes reach court. You'd have to be a family historian, counsellor, social worker, and indeed sometimes frankly a miracle worker to prevent these disputes reaching court often. So what you can do is to minimise this. And if the dispute is inevitable, to provide clarity. Clarity as to the state of mind of the testator, clarity as to why they were doing what they were doing, which is going to be very valuable to the court when they have to decide the outcome of these cases. I'm going to give you an example from a couple of years ago or so, a case called Coles against Reynolds. It was a decision of His Honour Judge Matthews sitting in the High Court in Bristol. It was a sibling rivalry case. And it's a sort of a very good example of this dispute was always brewing sort of case, because a mother had disinherited one of her daughters, the claimant, in favour of the other, the first defendant in that case. And emotions were obviously running so high that the judge felt the need in his judgment to set aside a little section about what the case really wasn't about, what it was about and what it wasn't about. And I'm going to read you what he said. He said, under oath, he said what this case is about. He said, because of the poor relationship between the parties, it's important at the outset to make clear what this case is about and what it is not about. This case is not about the failure of the relationship between the claimant and the first defendant. It is not about why the claimant lost contact with the deceased, whether it was anyone's fault. And in particular, it's not about whether one or the other of the two sisters was a better daughter or did more for the deceased during her last years. And I'll say that's quite typical. The observation that the judge is making there is that a lot of these cases do become almost a competition for who was the better parent, or who was the more deserving family member. And the judge went on to say, what this is really about, in this case, it's about knowledge and approval, due execution, and possibly undue influence. And the focus of the court is to focus its inquiry on the process by which the document has come about, and to see whether it truly reflects the testator's free and capable volition. And the judge went on to say this, which is a fairly standard warning, I think, that courts will give about disputes. Family litigation about wills and other transactions carried out by the deceased shortly before death can easily become a proxy for disagreements between the parties about quite different matters occurring during the life of the deceased. Von Clausewitz said, war is the continuation of politics by other means. So too probate litigation. And he added, disproportionately expensive. The good news in that case, the importance of the will file in that case was actually, it was well kept. And it did provide the key for the judge to unlock the dispute and to find in that case that the will was valid. Because what the will writer had done was to very carefully record the reasons why mother was disinheriting the claim of one of her daughters. And there was an attendance note. So the will was made in 2012, and the attendance, there was an attendance note, and then a separate statement of reasons had been produced, which said, signed by the testatrix, and she said, I have not had any contact with my daughter since January 2011, so over a year previously. My daughter refuses to ring me and has told me that if I want to speak to her, then I must ring her. So there was a statement of reasons included from the horse's mouth, if you like, why the relationship had broken down so badly. And that was pivotal, actually, in the outcome of that case. As I say, there were reasons clearly expressed and clearly recorded why that lady had made the will in the way that she had. And I can see on the screen you've got the question: counsel's involvement at what stage? I'll give my view on that, but I'd appreciate yours too. I would say at the earliest possible stage. And I hear you cry, well, I'm bound to say that, aren't I? Because we want to be involved in interesting cases for you. But, and I say that for these reasons. It's the earliest opportunity you have to join the team, if you like, to meet the client, familiarize yourself, meet your client, and have some input in the process by which the case comes to be shaped, I think is vital, because at the end of the day, it's going to be counsel who's going to be advocating that case in court. And I think having the earliest hands-on involvement, because we receive our instructions from at a range of periods, from the first time a dispute is in the offing, right up to a couple of weeks before trial. And the latter is definitely not the best way in which to conduct litigation. I know you never do that, but it's so important, I think, to meet early. It doesn't mean we need to be there blow by blow, minute by minute on a full-time basis, because we're a referral profession and we can drop in and drop out as and when needed. And that's up to you, Anna, to say when we come in and we can give a view, because what we can provide also is some objectivity, because the case will be fresh to us.
Absolutely. I think that's always been the key point for me with counsel's involvement, because where the solicitor is doing what you sort of alluded to a few moments ago about being everything to the client, being that shoulder to cry on, but also being that initial point of contact to discuss the dispute, the provision of initial advice. There are often numerous practical and emotional issues which we have to support the client through, alongside looking with analysing their case legally. We can become too close to that issue or the personalities involved, and having the objectivity and having that element of separation in counsel's involvement, to my mind, is useful. That's a useful part of it. That doesn't mean that you don't involve counsel until the last minute, and it doesn't mean that you only involve counsel every 6 months. But having that separation does give that really important objective view, which I think certainly clients need to hear from time to time.
Well, I'm relieved you agree with me. I think that is what we're there for. You're fighting, you're shoulder to shoulder with the client all the way through the process, and it can just be, what we're there for is a second pair of eyes. To obviously we're outcome focused, so we will review it and say, I think the case could be heading in this direction, or I think these could be the important points, or indeed I think this could be the outcome, which can hopefully add a sort of renewed focus.
Yes,
that the case is promoted. I should say, we're not just attack dogs. We're not. Hopefully our usefulness, I hope you find this too, and it's not simply because we're off to war now, we're going to court, we need the barrister and representation in court, because it might still not reach that stage. Because the second pair of eyes, we can offer creative solutions, a new, fresh look at how to resolve them.
Yes.
Or indeed, I think some of the evidence is against us on this point. We should perhaps negotiate on this. Sometimes it can be more nuanced than merely, we're going to court, this is our barrister, let's go there inevitably, because the courts more and more are going to be pushing litigants towards exploring resolution outside the court service as far as possible, and sometimes inside, because you may be forced into an FDR, a dispute resolution hearing before a judge, early neutral evaluation. It always makes sense to mediate these cases, and it's safe in the most extreme situations. And counsel can
certainly. Yeah, absolutely. And I think particularly with contested probate cases, as the judge commented in the case you just referred to, the costs by the point of trial are wholly disproportionate. And the benefit of early neutral evaluation and the benefit of an early mediation is something that we will advise clients on immediately, even before proceedings are underway. Whereas, that in other types of litigation, it's just not something that the parties are willing to engage in until there's a really serious issue before the court. But for us, we see the way that things escalate, and we see that in these cases, it is so often the most healing approach to have an early resolution, so that people can move on with their lives and begin to grieve, because that essentially is quite often put on hold when a dispute arises. So it can bring resolution to a number of different factors for the client. And one point which I'm always mindful of talking about with clients is the risk that personalities and principles become a barrier to settlement. Certainly for contested probate matters, this involves family disputes. This involves historic issues of family relationships, which again was helpfully summarised in the judgment in the case you referred to, where it isn't necessarily about the money. It isn't necessarily about the thing that's being fought over. Certainly, we see numerous situations where, simply because of the personalities involved, we know that a settlement is unlikely, or at least an early settlement is unlikely. And similarly, the amount of inquiries and approaches we have where people tell us it's not about the money, it's about the principle of the thing. They want to right a wrong rather than litigate a legal issue and receive some sort of tangible resolution. I don't know whether you have anything to comment on that. I'm sure that this your experience will follow mine on these aspects.
Yeah, absolutely, and well put, Eleanor. I think often clients will say to us, "We want you to say this is court, Mr. Moffat. It's a point of principle as much as the money, or sometimes the money, the difference between the two wills, the two rival wills over which they're fighting, isn't financially doesn't justify the enormous legal cost of taking the matter to the court." That's a red flag.
Yes.
Because we wouldn't be serving our clients well if we were to say, "Stop, let's take stock here." Well, you are not going to get that sort of emotional resolution that you're looking for. A judge is very sort of limited. Going to court is a very sort of blunt tool and will not provide you the satisfaction in the same way that the judge would not tell the litigants in Coles and Reynolds which one of the daughters the mother loved more. You're not going to get, that's not going to be the outcome of the case. You won't find that emotional satisfaction necessarily from the process. So it'd be a red flag to me if the class, it's all about principle, it's not about the money, because at the end, the court's powers are limited in that respect.
Absolutely, and as you say, it's the purpose of our instruction is to provide sensible advice to the clients, and that includes a bit of a reality check. And we see, as I've set out on this slide, the practical issues that can be a barrier to things. Where claims are issued too quickly, and the litigation is on foot before parties have had an opportunity to properly explore things in pre-action correspondence. And equally, when costs are incurred, significant levels of costs are incurred at an early stage, because there's masses of evidence to go through. There's medical evidence or will writers' files, and there are things which need to be explored before a claim can be legitimately set out in a letter of claim. The costs, become a reason for entrenchment and a reason for hostility. I have had to bear these costs because of what my brother or what my sister has done, and it can really be a mental block for clients. They cannot see past that, the investment that they have to make in their legal fees, and equally, as you quite rightly point out, the issue of family relationships and history, and the sentimental value of assets, and the lack of value that the court can attribute to the relationship between the deceased and the claimant, or the defendant. And that to most people embarking on contested probate litigation is really truly the crucial point. It's about the love, it's about the family relationship, it's about recognition for something that's been done over many years. It's not about the money or the possessions. And we see time and time again successful mediations, successful settlement discussions where a client gets what they want, but it doesn't bring them the happiness that they think that it will. It doesn't bring them the satisfaction of being successful in their claim. In fact, it can often lead to pretty deep and meaningful conversations about, was this really worth it? And whether or not that is the beginning of their grieving process or not. It can have a real emotional impact, even in the case of a win, as it were. But in the circumstances where the trial is inevitable and everything, all attempts have been made. The will writer has created a perfect file. The solicitor has done everything they can in pre-action correspondence, and the executors have behaved impeccably. Even in those situations, that sometimes the trial is inevitable.
Yeah, as I said at the start, and I think that is the case. However impeccably, and also however much the legal advisors, as we've just described, taken the client through the process of the proportionality and the desirability of going to trial. There are going to be those cases where we just have to gear up for battle, and that's where the will file is so crucial. And brings us back. I was thinking you were saying that sometimes there are parties can be close to a resolution but fall out over who gets a particular object of sentimental value. And I was thinking you can sometimes mitigate that if you can anticipate in the will-making process there's going to be there's a particular object which is family heirloom. And if the will provided for the destination of that, would that minimize the risk of dispute? Well, sometimes. I think if there's a particular object which has been in the family for generations, and they're going to end up parting over, let's just say, even if it's not particularly valuable, let's just say who it's intended for. But my feeling is that if it weren't that object, it would be another sometimes, and you'd end up probably in court anyway. So yeah, let's fast forward to that. We've given our advice on possible resolution outside court, and the court indeed has pointed the litigants in that direction, but it's been unsuccessful. Parties are reaching trial. Yes, the will file is crucial. Clearly, the key evidence that we're going to be reviewing, counsel is going to be reviewing, are going to be evidence of lay witnesses, so those that knew the deceased, witnesses to the will, of course. If it's a capacity case, clearly expert reports are going to be vital, medical records are going to be vital, and close scrutiny of the steps that were taken by the will writer to assess capacity. Whether that's going to get a letter from the GP saying, assessing capacity, or whether it's an assessment made on the day with the testator face to face. Pause there to say, an experienced will writer assessing capacity face to face is something the court will give weight to. We've seen a number of cases in which the courts have those whose job it is to assess capacity, even though they're not medics, they're will writers, but have proper conversation, a bold conversation, just along the lines that Eleanor is describing, that can be determinative, and the court can give it a particular weight. Because after all, the will writer doesn't benefit from the will. They have no axe to grind in that respect. So they are given proper weight. So the will file itself is always the first place we go into preparing these cases. It will be scrutinized line by line in a way that most of you would hope never to happen, but in a dispute, that is exactly what happens. We get the attendance notes are key, and we see, in the cases in which I've been involved, one sees a wonderful array from the completely non-existent, which is obviously a red flag, to the exceptionally full and thorough attendance note, which feels almost like a verbatim account of the conversation in whichever direction it turned. And I think they're often, they're wonderful. I've never heard or known of a judge complain of an attendance note that was too long. There's no such thing. Almost the more thorough, the better. I think what I would say, just looking back on cases that have litigated, almost the worst, where there is an attendance note, almost the worst thing is the enigmatic attendance note. The one that has comments that aren't fully explained or leads to further inquiries which aren't made. And they sort of hang there. And each party can sort of put their spin on the way in which this attendance note is being prepared. I'll give you 3 short examples, 2 from my own experience in cases in which I've been involved, and 1 from a recent reported case. I had a case in which the testator had left everything to charity and not to relatives. The attendance note was quite brief, but quite staccato. It had a very short introductory passage about, chatted about the weather. United won. They're trying to kill the Queen. I want to leave my estate to charity. That's my paraphrase side, but there was just within, you could almost sort of, you wondered of the train of thought, but it was true that United had won the match the evening before. The comment they're trying to kill the Queen obviously leapt out off the page. And those that were seeking to challenge this said, well, clearly this person is delusional. There's been no assassination attempt on the Queen whatsoever. But what it was, on further investigation, after far too much argument had been generated over these few words, was that it was made shortly after the Diamond Jubilee celebrations, in which the Queen had spent 4 hours on a very cold barge on the Thames in a rainstorm. And the testator was making a joke about, I see they're trying to finish off our dear Queen, something to that effect. But it had not been recorded very fully, and it had everyone speculating for a very long time that this person might have been delusional. There were question marks over their mental capacity. And we did eventually resolve it by checking the dates and what was in the news that day. But the maker of the note themselves couldn't quite remember what was meant by it, because they hadn't given themselves the little clues to put themselves, perhaps if they put brackets joke afterwards, might have helped. But a second example, a very, very thorough attendance note in a matter that reached court, where it was almost everything that had been said. And this particular old lady had given a very, very long account of her entire family history. Perhaps she was been visiting a care home with a lot of people in business suits sitting around, and she decided to entertain them all with the as I'm sure you sometimes find, you'll get a full family history, way back from grandfather who opened a shop down the end of the road, etc. And on about page 17, there was a comment that said, I don't speak to my daughter so much anymore. She listens into all my telephone. And then it went on to something else. It was a very brief mention. What the will was made and was invalid, but had the person making that attendance note perhaps interrupted at some point or asked a bit more about the daughter who listened into the telephone calls. So what it transpired, there was medical evidence that accompanied it that revealed that had the will writer asked what this eavesdropping was, it wasn't just eavesdropping in the background, listening into my calls. The lady, who was otherwise perfectly lucid and capable in every other respect, had nonetheless developed a paranoid delusion that her daughter had bugged every object in the room and was listening in as they were speaking. And had that been investigated just a little bit further, all of this would have come out, you feel, because the testatrix made no secret of the fact that she believed her daughter was bugging her. It wasn't true. And would have discussed it. She discussed it openly with others, just not on that occasion. So you feel like you want to go back in the time machine and ask that vital extra question that's left hanging there. And I think that the same applies to the last of my three examples, which is a recent reported case called Boast and Bellardi from last year. It was a decision of the Chancery Master Clerk, and it was about the estate of a Mr. Smith, who made a will in 2013. And there was an underlying history of issues with mental capacity. And in fact, he'd seen a medic and had been assessed negatively indeed before making the will. And the claim was brought by his great nephew, Mr. Boast, who'd been disinherited. Or partly disinherited. So the medic who'd seen Mr. Smith the year before he made his will had made a note that said things like, Mr. Smith thinks that he's a professional hypnotist. He wasn't. And that he'd been treating victims of shell shock during the war, which I think was a reference to the Great War. He complained to his nephew about one of his carers stripping off in front of him and saying he wasn't going to put up with that kind of behavior. So there was a lot of delusional and troubling aspects to what he was telling the medic. And the medic said that he was presented as a calm, pleasant and cooperative person, but did express a few eccentric and possibly delusional ideas, including some rather grandiose sounding ones. From the content of much of his conversation, it would appear that he's actually an intelligent and well-read man, even if the material he prefers to refer to is many decades out of date. So here's a gentleman who is quite eloquent, obviously intelligent, and yet with old age, unfortunately, a mental condition that was deteriorating. And the medic didn't think he was capable of making an LPA on that occasion. So he then goes, Mr. Smith then instructs a solicitor, Mr. Margeson, to make a will for him. Now, Mr. Margeson is aware of some of the medical history and asks him about it, and asks him about whether he could provide a medical certificate. He gets the reply from Mr. Smith. He says, I'm okay mentally, it's physical, I'm a bit bodily. And he says, and then in this letter, he said, there's no doubt that this industrial park is a shambles. I should say he was living with his nephew, Terry, whose address was on an industrial park. So that in itself wasn't a troubling comment. But he goes on to say, my nephew has given over the whole enterprise to an Asian immigrant who runs everybody and everything. By hypnotism, mass hypnotism, she's extremely wealthy and I fear will disappear one day with all the assets, including mine, if I do not remove them from her domain. She's an Asian immigrant from Laos and could disappear at any moment with all the cash she can lay her hands on. I'm anxious to avoid this in any case, but my relatives are blind and deaf, and I'm concerned with their fate. And then he says, I wish my two sisters to have what I own needed. So he left everything to his sisters. Now, Mr. Margeson was presented with something of a dilemma. A man who was eloquent and clearly quite intelligent was expressing this rather extreme view about an Asian lady who was running the industrial park. Mr. Margeson decided to make the will, and he made a note to himself saying, an attendance note saying he clearly has a fixed view about foreign immigrants and probably coloured people. He's under the impression that the industrial site is actually owned by a foreign lady until she's making considerable money from all concerned. Mr. Smith is rather fixated about this, although it does not appear to alter his judgment as to other matters. Mr. Smith told several stories about members of his family, as a 95-year-old would do, and everything in this respect was perfectly rational. Thus, apart from his fixation about the foreign lady mentioned above, Mr. Smith really felt he was still mentally competent, though physically frail. And he made the will, as I say. Now, this, as I said earlier, was one of those cases you want to go back in the time machine and ask that extra question, because if Mr. Martin had asked who this foreign lady was, he would have found out that it was the wife of Terry, his nephew, and that not only was it a sort of harmless, discreet and isolated, delusional, and perhaps racist antipathy towards this lady, it was very much a factor that was capable of affecting his will-making volition. So again, it's just those frustrating moments you see cases where if that extra question had been asked, the one that it is begging and hasn't, perhaps matters would have been more quickly resolved. So those are my three examples, Eleanor. I hope useful ones from
Absolutely. And I think, you know, the benefit to all of us in these pieces of contested litigation going to trial is that we get some really colourful reports out of the judgment. So from our perspective, they're sort of, you know, tales from the front line and their warnings, but they're also relatively memorable when they have that sort of colourful circumstances attached to them. So thank you for sharing those. I really appreciate it. I mean, I think looking at the time, we've come to the end of our talk. I think it's been a great session, just taking that step back and looking at the overview of a piece of litigation and the pitfalls that we can all see.